What is the Canada Energy Regulator, or the CER? The Canada Energy Regulator is responsible for federal pipelines, power lines, energy development, and trade. The CER is located in Calgary, Alberta, and employs approximately 500 professionals across the country. With this, the Canadian Energy Regulator Act was established by the government in August 2019. This legislation contains key commitments that establish the CER's mandate, which includes ensuring safety, security, and environmental protection, enhancing Canada's global competitiveness, increasing transparency, diversity, and inclusion, advancing reconciliation with Indigenous peoples, and driving innovation. Earlier this year, the Canada Energy Regulator announced that they were looking for Indigenous people to join a new advisory committee. This fully Indigenous committee is expected to play a key advisory role to the regulator's board of directors. This committee is expected to have up to 7 members, 3 of which will be appointed to the committee by the Assembly of First Nations, Métis National Council, and the Inuit Tapiriit Katanami. In addition to this, the Canada Energy Regulator replaced the National Energy Board after the federal government passed Bill C-69 last year and is responsible for reviewing energy project proposals, making recommendations to Cabinet around issues and conditions for approval, and for oversight of existing pipelines and transmission lines. When looking at a historical context, it's clear that Canada has a history of settler colonialism against Indigenous peoples. Throughout history, Europeans have taken land from Indigenous peoples. This fully Indigenous advisory committee with the Canada Energy Regulator is the federal government making an active effort to include the Indigenous community in decisions regarding Canadian land. This is significant as Indigenous peoples have cultural ties to the land and as a result have specific rights to such land that provide them with some control over its use. This is the government making an active effort at reconciliation with Indigenous peoples in Canada. However, when looking in terms of a legal context, the ILO Convention 169 proves that Indigenous peoples should have land rights in order to maintain their cultural and traditional heritage. For example, according to Article 6 of the ILO Convention 169, governments shall consult the peoples concerned through appropriate procedures and in particular through their representative institutions, whenever consideration is being given to legislative or administrative measures which may affect them directly. Establish means by which these peoples can freely participate, to at least the same extent as other sectors of the population, at all levels of decision-making in elective institutions and administrative and other bodies responsible for policies and programs which concern them, and establish means for the full development of these people's own institutions and initiatives, and in appropriate cases, provide the resources necessary for this purpose. The ILO Convention 169 also mentions that governments are to respect the spiritual and cultural importance for the relationship of Indigenous peoples and the lands or territories. More specifically, the Convention states that the rights of the peoples concerned to the natural resources pertaining to their lands shall be specifically safeguarded. According to the Convention, this includes right of these peoples to participate in the use, management, and conservation of these resources. During this time, due to COVID-19, there have been little to no new developments in this case. However, applications for the Fully Indigenous Advisory Board closed on May 31, 2020, and are currently under review by the Canada Energy Regulator. With this, there's no specific date as to when the advisory committee is to be released. However, according to CBC, the hope is to have the new committee finalized sometime this summer.